This program is recorded and presented by Chippewa Valley Community Television. The audio for this program can be heard on WRFP LP 101.9 FM.
Well, good evening, everyone. I'm pleased to call this meeting of the Eau Claire County Board of Supervisors to order here on October 18th, 2016. Please rise for the Pledge of Allegiance, followed by a moment of reflection by Supervisor Michael Conlon. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
When I was asked to do this, I first thought of bringing a mirror, but I thought that'd be a little bit making too light of this. Actually, I would like to talk about something that's been an inspiration to me, but also starting to bother me. And I've always been proud of the fact that we are one of the first modern governments that was based on the idea that each and every one of us has some God-given rights. You know, inalienable rights. Rights that are to us not because we have a Constitution, but because we are people. And the Constitution is not granting us these rights, and the government is not granting us these rights. We have these rights, and they serve to protect them. And the thing is, that's bothering me, is that we are starting to lose sight of that, in my opinion. If you look at our rights, freedom of speech, freedom of religion, freedom, right to bear arms, freedom of assembly, petition the government, all these rights can be exercised by every one of us if we do it responsibly. And they will not infringe on anybody else's rights. Of course, your freedom of speech ends when you yell outside my house at 2 in the morning, but if you use it responsibly, you don't infringe on other people's rights. What's bothering me is that people are starting to misuse the word right. They're talking about a right to a commodity, a right to health care, a right to a home, a right to certain things. And you cannot have a God-given right for something that must be created by other people. We fought a war against that idea. And when we extend, they're confusing the word right with a sense of moral responsibility. But if I have a moral responsibility to do something, that doesn't mean you have a right to expect it. So I really wish and hope people start to realize what our rights truly are, and we as governing officials work to defend those rights. Thank you.
Thank you, Supervisor Conlon. And now if supervisors would take your keypad, please, and indicate your presence here this evening. And I know Supervisors Willett is here, and Supervisor Lavelle, if you'd redo that, please. And we've got 26 present. We have a quorum. Thank you, everyone. We'll move on to approval of the Journal of Proceedings from October 4th. You'll find that on pages 3 to 4 of your meeting packet. Are there any suggested changes to the Journal of Proceedings as drafted? None. I would look for a motion to approve as drafted. Motion by Supervisor Olson, second by Supervisor Willett. Any discussion? I see none. All in favor say aye. Aye. Opposed, no. That is approved. Moving on to public comment period. This is an opportunity at meetings for individuals to speak to the board. We ask folks to limit their remarks to 3 minutes, and we have one person this evening, Brandon Adkins. So if you'd come forward, please, sir. Welcome.
Thank you. All right, I promise I'll keep my comments brief this evening. One, I just wanted to share my appreciation for what you guys have done to us or helped us out with in the last board meeting. We weren't able to speak after that, so I just wanted to express our gratitude for my board here that certainly helped us out and represented us the last meeting. Two, I also wanted to give you just a brief update after that last rainstorm that we had shortly after the board meeting. There was some things that we found out about our house. One, we woke up that next morning and we had a geyser that was shooting out of the ditch next to the county road. So that was shooting out about 12 inches and ran for, I don't know, the next 36 hours. There's a decent sized sinkhole that's there now. And then the layer of shale in the backyard, there was so much water pressure under that it blew the whole top part up and off of the layer of shale, and the whole backyard was just seeping water out of it. So we spoke with another engineer that came out and gave us some recommended changes in that, and we've submitted that to the county's insurance company, and we're right now just waiting to hear their response. So I thought it'd be nice if we stopped by and just shared our appreciation for what you guys did for us. My heart's very full for the effort that you guys gave and discussion, and then two, just I thought it was fair that we'd give you an update on kind of where we're at in the process and what's going on. So that's all I have, and thank you guys very much.
Thank you. Is there anyone else from the public who'd like to speak this evening that didn't sign the sheet? I don't see any. We'll move on. Our annual report, and we've got presiding judge of the circuit courts, Judge Gaber. So welcome, Judge. And while you're coming up, let me tell you who's here at the head tables. We have Cynthia O'Donoghue. Cynthia is a deputy in the county clerk's office who is getting trained on how things work up here, so that particularly during the budget session, when Janet might not be here, Cynthia will be filling in and can help out in the future. So welcome, Cynthia, and welcome, Judge.
Thank you, Mr. Chairman. The last oral report I gave was in 2014. Since that time, I wanted to talk about two things. Primarily, the fact that we need a new judgeship here in Eau Claire County. And in addition to needing a new judgeship, there has to be some significant remodeling of what we call the second floor of the courthouse of this building. We need another judgeship. We need a branch 6 because it is very difficult for citizens to get on our calendars. Before I came down here, I used a feature on my calendar, and I wondered, how much time would somebody have to wait to get on my calendar and have an hour of my time? On the Branch 3 calendar, the first time there's a free hour is October 31st of this year. Then I plugged in one day. If somebody needed to have one day on the Branch 3 Circuit Court calendar, when's the first time I can give them one day? Well, the first time I can give one day is December 27th. And the next day is December 29th. And then I thought, well, lots of trials and hearings take more than one day. When is the first time that I have 2 days open on my calendar? And it's the middle of March of 2017. There just isn't enough access for the citizens of Eau Claire County to have access to the judicial system. And the statistics bear this out. This past summer, the National Center for State Courts did and completed a Wisconsin judicial workload assessment. It was a comprehensive statewide assessment. Every single circuit judge and every single court commissioner in the state of Wisconsin participated in this month-long process of collecting and reporting data. As a result of that workload assessment, based upon those statistics and also based upon the ranking by the Supreme Court's Committee of Chief Judges, Eau Claire County ranks 11th in the state priority for judicial need. Ahead of us, local nearby counties include Dunn County, Jackson County, Clark County, all of which are ahead of us. And in the state, we are number 11. Judicial need is determined by three primary factors. One is, I should say, the ability to obtain a judge is based on three factors. One is judicial need, which we have. Another is facilities availability, which we have. We have the space. And the other is local support. Counties will not get another judge unless the county board passes a resolution saying, yes, we want a judge. Yes, we will provide the adequate space. The last time a judge was added to Eau Claire County was in 1994. When my term ends and when Judge Lenz's term ends on July 31st of 2018, it will be 24 years since we added a judicial position in Eau Claire County. The time before that was 1988. In 1994, and I got this from the Wisconsin Blue Book, in 1994 the population of Eau Claire County was just a little more than 85,000. In 2014, the estimate was it was a little over 100,000. That's a 15% growth in 20 years. The second floor of the courthouse, which houses the DA and the clerk of court and the register and probate, that hasn't undergone a substantial remodel since 1988, when the old county boardroom and the Branch 3 circuit courtroom was added. So it's time for some major revision in addition to adding another judge on the second floor. The statistics show that Eau Claire needs actually an additional 1.25 judges. Now, you may not think that's very much, an additional 1.25 judges. Why can't 5 judges split up 25% of the workload? Well, there are reasons for that. And the reasons for that is that back in 1994, when the 5th branch of the circuit court was added, there were a lot of things we didn't have. We didn't have any treatment courts. There wasn't drug court, AIM court, or mental health court. We didn't have a meth traffic. We didn't have methamphetamine addiction. We didn't have a significant opioid addiction problem like we have now. We didn't have the spike in domestic violence. We didn't have computer sex crimes back in 1994. Now we are awash in computer sex crimes, and they consume time, resources, and energy. There's been a huge increase in pro se litigants, individuals who represent themselves, and individuals who represent themselves. It takes more time to explain, to do their legal research, to help them along, and this is a new wrinkle. One thing that the caseloads don't reflect is all the time we spend on cases that are closed. You know, you think that if a case is closed, well, it's closed and you'll never see that case again. That isn't true. We spend a lot of time on closed cases. Post-conviction motions and hearings in criminal cases, post-conviction motions and hearing in family law cases, children's cases, and then for some reason there's been a huge explosion, hopefully it's temporary, in civil jury trials that we have scheduled. Right now, there are 10 civil jury trials scheduled in the circuit court that are going to last a week or more. Many for 2 weeks, and Judge Schumacher has one that's going to last 5 weeks. When you take that much time out of a judge's calendar, things wait. And so this is a real need that is demonstrated by statistics. Happily enough, Catherine Schaaf indicated, and we've been talking about this, that in 2017 there's going to be a capital budget facilities master plan. And we thank you for that. And we hope that the circuit court and the needs of the people of Eau Claire County are included in that. I know I plan to be part of that. So to lay the foundation, to lay the groundwork for the 6th branch of a circuit court, which will only occur long after I'm gone and after Judge Lenz is gone. Something else that's part and the parcel of that, of course, is a revamping of the second floor. We can't have a 6th judge without redoing that second floor. And that's going to be part of the capital budget facilities plan, because we have to have a competent plan that will take us years and years down the road to include and address such things as screening, safety, not only for the second floor, but safety for the entire building, for the entire structure. So that's what is on the docket for the courts next year, and the 2 and 3 and 4 years after that. That's my report.
Well, thank you so much, Judge. Any questions for Judge Gabler this evening? Any questions or comments? Oh, Supervisor Dunning.
If you were to get the approval, if we were to do this, how soon would you get that position appointed? I mean, regardless of infrastructure, et cetera, how soon could you have a judge in place?
Well, I found out that happily enough, judges are not tied to the state budget, so they're not part of the budget system.
Having been the court administrator, I can answer, it wouldn't be included in the budget bill, but it probably wouldn't take effect in the next budget year, so I'm thinking August 1 of 19 is probably the earliest.
Probably so.
August 1 of 19 is the
Right.
earliest you could get under any circumstance
Right.
with, okay.
Right, yeah, which is a long ways away.
Supervisor Bates.
Thank you, Mr. Chair. First of all, I really would like to thank the judges for taking on the extra responsibility and time for the treatment courts. Certainly when we started them, we knew that you already had full calendars. And for you to work that out in order that we could make that turn, if you will, in the justice system is remarkable to me. I also look at some of our indicators in our community, like the 1,350 child abuse reports from 2014 and the 1,200 and some in 2015, and realize that we're only at the beginning of what we need as far as that type of collaboration that allows us to handle those courts, those that need to be in your court, more effectively. So I hope this board will take time to look at our poverty level, to look at the things that in our community make issues for us, and realize that working together, we should be able to address those issues in a different way and supply our judges with the space and the personnel they need.
Thank you, we appreciate that, we do.
Supervisor Wilkie.
Judge, hearing what our chair said, that the earliest is 2019, would it be prudent on our part, though, to be moving on a resolution being brought before this board now so that we can get in line hopefully in support of a request for a judge, or is this something we should be waiting on for a later date?
Well, offhand, I'd say we certainly wouldn't turn that offer down. It might be a good idea. I don't, Mr. Chairman, as a former court administrator, what's your recollection of strategically?
Sure, I think probably sooner than later, the Judiciary and Law Committee should put it on their agenda for discussion, and I know you're on that, and Supervisor Miller. And let me just clarify the August 1, 19. Technically, it could be, anytime. August 1 is the start date, but typically, what'll happen will be a separate standalone piece of legislation, an omnibus bill for so many judgeships, 6 to 12 typically. Every few years, an omnibus judgeship bill goes through, and to get in the package, if you will, then the county board support is needed. And usually the reason it's August 1 of even numbered years is it's adopted during one budget session, but the effective date isn't until the next budget effective date, which is why I think it's likely August 1, 19. But it could be August 1 of 18, but because judges are paid by the state, it's in the state budget on that piece of it, and so it's just typically adopted in even numbered years to take effect in odd numbered years.
Plus, we'd probably have to do an awful lot of work on that second floor, moving walls and doors and I do know that, and I just found this out today, that there is pending in the legislature, and I don't know its exact status, a bill for a Dunn County judge. Dunn County is number 2. The state order is Vilas County, Dunn, Jackson, Wood, Sawyer, Langlade, Clark, Waushara, Marathon County, Columbia County, and then Eau Claire is 11. So I'm sure that there's something else in the legislature besides Dunn County, but I don't know. But let's pursue that. That's a good idea.
Supervisor Conlon.
Yeah, just one question. Other than renovating the upstairs and the judge chambers, et cetera, what other infrastructure does the county need to provide for another court in terms of personnel or other equipment?
Well, probably another judicial assistant. We need another judicial assistant, but as far as extra space, none other than for the judge, but then reworking that entire floor, and we could spend about 15 minutes talking about that, but we won't. So the judge is paid by the state, court reporter is paid by the state, and so in terms of personnel, probably the only thing would be one more judicial assistant, because we've got 4 judicial assistants now, taking care of 5 judges and 1 court commissioner, and so we would probably need another judicial assistant.
Thank you. Any other questions? I see none. Thank you,
Okay.
Judge, and thanks for
Thank
your
you. And
leadership.
thank you for
on
your
the-
support.
And also
Appreciate it.
thanks for your leadership on Criminal Justice Collaborating Council, because you're the chair, as many, but maybe not all of you know, Judge Gabler chairs the
Okay.
CJCC, so.
Thank you.
Thank you.
Appreciate being here.
Okay, thanks. Next, County Administrator update. Administrator Schaaf.
Thank you. I will be very brief. You actually have a copy, a hard copy of the budget on your desks. It has also been sent to you electronically. If you have any questions about the document, please feel free to call department heads, myself, members of the Finance Committee, if you have questions about that budget. Also, one item that I sent an email about just a moment ago is the budget amendment process. The board will use the budget amendment process that was instituted last year. What that offers board members is the opportunity to take an item where you may want to make an amendment and have a conversation with the affected department heads or administration. Finance will help you craft that amendment so that we can do the research ahead of time, so that when your amendment is proposed, some of that back work has already been done. We will then compile the results that we receive from you, and we will present them to you as part of the board packet when you have the actual budget document before you. This is so that you, as a board and a body, can see ahead of time what some of the different thoughts of your peers are, and it allows members to give some concentrated effort to how they may want to amend the budget. Again, I would encourage you to take advantage of conversations with department heads about what the potential effect of different amendments may be ahead of time. I think that will help you significantly as you contemplate how you may want to amend the budget, if at all. Again, if you have any questions, the doors are open and we encourage conversation around it. The other item on my report is the Economic Development Summit that is coming up. We've had very beneficial input for a number of you, and I thank you for that. The summit is something that we are looking forward to from the standpoint of focusing the efforts in Eau Claire County as well as the region. There are many partners that we'll be working with, not only in the city of Eau Claire County as a whole, but also the region. I will be presenting regular updates to you as a body as to the progress of that summit, the first of which is coming up. And as the participants in that begin to formulate the overall direction, because that is one of the things that we are asking them to do, we'll be sharing that with you as well. So you will be kept apprised. We're also going to be creating a website so that we can share information very quickly with all of the participants as well as the community as a whole. And that is all I have for my report this evening, unless there are questions.
Thank you, Catherine. Any questions for Catherine this evening? Supervisor Clark.
No, I'm out of order. I'll wait.
Okay, that's easy. Okay, I don't see any questions. Thank you very much. We'll move on to, well, there's a variety of written reports in your meeting packet, and we'll go to a presentation of petitions, claims, and communications. Any announcements that anyone would like to make? Supervisor Olson.
Thank you. I received a memo from the Wisconsin County Association about the County Ambassador Program, and they're looking for a representative from our county. I served on this last year. The dates have been set for when they're going to meet. Be January 18th, April 5th, and October 25th of 17. And if anyone is interested in filling this, they'd like to have a name by November 18th. And I have an application. If you want to contact me or not, if you're interested, and or if you want to know a little bit about the program, I'd be glad to talk about it. And you know, if no one else is interested, I guess I, you know, would be willing to do it another year. But if someone has a, you know, real interest in it, I'd be glad to let them take that spot.
Okay, thank you. And if you're interested, yeah, why don't you get me your information? That'd be great, because I believe the county board chair is supposed to kind of sign off too, so that's great. Thank you. Any other announcements? I'll just mention on budget, we had made this change earlier, but just a reminder. So our budget will start at 7 o'clock on Wednesday, November 9th. And we'll start with the public hearing, of course, and finish up by 11, and then reconvene, presumably as needed or if needed, on Thursday, November 10th at 1 o'clock. So please make sure that's on your calendar. Okay, seeing no other announcements, we'll move on to agenda item 8, first reading of ordinances by committee.
File number 53 is to create section 2.04.140K of the code, general duties and powers of standing committees.
And we'll bring that back at our next meeting. Agenda item 10, reports of standing committees, file 51.
Requesting that circuit judges be given direction regarding adding the DNA surcharge to each and every count in criminal judgments of conviction. And on the agenda, it said county, but it means count in criminal judgments.
May I have a motion? A motion by Supervisor Miller with a second by Supervisor Henning, and an explanation by Supervisor Miller.
Thank you, Mr. Chair. Discussion relative to this resolution actually began earlier this year while we were in budget discussions with our different departments, and predominantly the courts and the sheriff's department. Back in 2015, the state enacted a new mandate that in effect said all individuals who go through the court system and are convicted on either a felony or a misdemeanor should be given a surcharge fee as part of the court costs. And the fact sheet that came with the resolution indicates the dollar amount that's involved with that. Now, the DNA test is given just once to the individual, obviously. The Sheriff's Department is the one who oversees the administration of that. We as a county receive $10 for each test, which does not even meet or cover the staffing expenses to handle this. But the point is that the judges themselves feel this added surcharge on top of court costs is starting to really create, and they have to apply it. They don't have a discretion as to whether they can or cannot apply it. They're starting to see that this is starting to become quite a financial burden for a number of individuals. And on top of that, you know, if there's any tax intercept collection type stuff that goes on with restitution and court costs, well, as you all know, child support gets the first, restitution before fines and so on. That money is collected and paid out before the county or the state or anybody else would get any of that. However, for the period that, and I want to thank Keith for doing the research on this, between July 2015 through June 30th, the State Department actually collected over $5 million on these DNA surcharges. And what they say they're using it, they hired a few more staff to help in the crime labs, and that they're using it for some training of the DAs and how to use DNA analysis and so on. Well, that's all fine and good, but locally, we don't see any of that, and it's adding an increased burden, and the judges are very uncomfortable with this. So we were asked to consider bringing forth a resolution that simply says to allow the judges to have discretion at when to apply this surcharge. So I'd be happy if my colleagues in the committee want to add anything more, or if I've forgotten something, or if I can answer any other questions.
Great. Thank you for that explanation, Supervisor Miller. Open up for discussion. Supervisor Wilkie.
This is kind of a topic that continually comes before this board when we do resolutions. As was stated, it really comes down to two things. Our state elected officials will tell us time and time again that they recognize local control, local decisions are best done at the local level, closest to the people. And they say that they don't like underfunded or not funded mandates. However, we've seen time and time again the practice doesn't follow through. And that's what this really comes down to. We elect our local judges to judge. In this case, they cannot judge. And it becomes obsessive in terms of the amount of fines that have to be mandated. And of course, as indicated in your fact sheet, the state is right in there before the county to take its cut, if we ever get in anything at all. I don't know that it necessarily will change their minds, because what they preach, they don't practice, but I think we have an obligation that every time we see them taking away local control closer to the people, or doing an underfunded or a non-funded mandate, that we have an obligation to draw it to their attention. And that's what essentially this resolution does.
Thank you. Any other comments or discussion? Supervisor Beckfield.
My only question is who pays for it if the judge decides not to charge the individual?
Supervisor Miller, please.
Well, it's actually just an added fee that goes to the state. And it's not for the test itself. The person pays for the test, which is only $10. But then that surcharge of the $200 and $250 just goes to the state. That comes from the individual that is in the court. Okay? So it's not, it's an added cost, the court cost, that it goes, just like I said, goes directly to the state.
Supervisor Olson.
I guess what I see missing in this fact sheet is anything from the DA's office or from law enforcement stating that they support this. DNA testing was set up on a purpose to help deter crime, to help set up a DNA base file for past cases, things like that. And this is just coming from the judges. I don't see anything from the DA or law enforcement supporting this, so I guess at this time, I couldn't support this recommendation.
Supervisor Miller, do you know what the sheriff's department?
Oh, yes, definitely. Actually, like I said, this came about through when we were doing all of the department's budgets. And they're fully supported of the DNA part of it itself. Okay, that's not the question here, Supervisor Olson. It's not the DNA test per se. It is the surcharge that was added on top of that mandates the judges added to the whole court costs, and they have no discretionary impact on that, okay? That's where the DA and the judges and the sheriff's department have had concerns. But they are fully supportive of the DNA test because it is very, very helpful, obviously.
Maybe just to clarify, are you saying that the sheriff and the district attorney are supportive of this proposed ordinance?
Correct, correct.
Or proposed resolution, I mean to say.
Can I follow up on
Follow
that?
up, yes, Supervisor Olson.
I guess, you know, I hear all the time of law enforcement and the DAs complaining about the backlog of all this DNA evidence all the time. And apparently this is what's funding those lab techs to do that work. And if we eliminate some of that money, that's going to eliminate some of that, and it's going to create even more of a backlog. So, you know, yeah, we may be the bottom feeders on the situation, but somewhere we have to pay to have the extra lab technicians, the extra staff in the state crime labs. And to me, this seems like that's the funding mechanism that you're trying to eliminate by saying we don't have to order this.
Supervisor Conlon.
I kind of agree with Supervisor Olson. My question is, these surcharges are only applicable if they're convicted, am I correct?
Supervisor Miller?
Yes.
So they're very much akin to mandatory minimum sentencing or other things. So if you kind of agree with that, then you would agree with this. But if you don't agree with minimum sentencings, you would disagree with this as far as the mandatory surcharges per count. It does appear that some of the DNA charges of the convicted would go towards the DNA data bank, which I think everybody agrees is a good thing. So, you know, perhaps it's overkill or perhaps it's not, but I don't think we've heard enough of both sides to really weigh it. I mean, we might have an opinion, but I'm sure there's plenty of other opinions, both pro and con, so I don't think I can support it this time without a little bit more evidence.
Supervisor Wilkie.
Well, I think the question was already answered. Yeah, there's going to be a need for lab technicians from the county side. In fact, I think you're going to see that moving forward that we're going to have to do. But keeping in mind, the county only gets $10 one time, not each and every count like the state is mandating the judges must do, which becomes excessive and it takes away their ability for the judge to judge. And yes, the concept of the DNA surcharge don't have objections to, and it's an essential thing. And yes, law enforcement has concerns about this. The $10 doesn't even come close to covering our costs. But yet you see this big, gigantic chunk of money going to the state and not nearly an adequate share coming to the county. That's an objection. And understandably taking the discretion away from the judges to judge locally what should happen is not a good practice. That's what this resolution is all about. Not any opposition whatsoever to a DNA surcharge, a more reasonable one and a more equitable one in terms of where that money is distributed.
Supervisor Dunning.
I guess I ask a question of Supervisor Miller. If they don't pay those charges currently, who has to do the collecting and what is the collection process?
Well, the collection process still goes through the county clerk of courts, and then it's all sent right to Madison. And if they aren't paying, they aren't paying. Different means are taken after a period of time with collection agencies and other types of avenues in that regard to get the money on any case, okay? But I think Supervisor Wilkie was trying to point out, this is an added fee on top of the court costs for every count, whether it's misdemeanor or felony. And the judges don't have the discretion as to whether to add that fee. They have to, regardless. Whether and it really doesn't serve their purpose of ensuring that justice is done. It's just an added fee that the state gets. Okay.
To follow up, I think with that in mind, it's going to cost the county more to not pass it. I mean, if we pass this resolution, it should save us money in the long run because we're not out trying to collect. We're not out, if someone has, for 3 felonies in one time, that's triple what's going on. With people can't afford it, they might end up back in jail again. So and we're footing the bill there. So this is almost, from my perspective, almost a no-brainer as far as that we need to pass this resolution.
Oh, we need to, okay.
Supervisor Leary. Yeah, I'm hitting, okay, try it again. My question is your light on?
The light is white.
Okay, why don't you press it? Why don't you press it? And now try it. Yes.
Turn it back on, push it back on.
Yeah.
Thank you, Mr. Supervisor Willett. Supervisor Miller, my question is, do we have anyone sitting in jail that, because they can't pay these extraneous fees, end up sitting there incarcerated longer because of this?
I don't think I can really answer that for you. I don't know for certain. Okay.
Thank you.
Let's see, Supervisor Conlon, second time.
Yeah, I'm a little bit confused. On line 13 and 14 of the resolution, it says the surcharge for misdemeanors is $200 and $250 for felonies. And the total court costs for each misdemeanor count is $443 and the felony count is $518. Is that the actual costs or is that the charges or what? I'm unclear as to what the meaning of that is.
Supervisor Miller or Keith, do you know what goes into the court costs items?
I can't tell you exactly what's all in the court costs, but those are mandatory court costs. This DNA surcharge is above and beyond that. So the combination of the 250 and other court costs are the two totals in the resolution.
Oh, okay, so what you're saying.
Those are going to be imposed no matter what. Those other costs are going to be imposed no matter what. And under the current law, the DNA surcharge is imposed for each count of conviction over and above the court costs.
So if you're convicted of a misdemeanor, as an example, you would be charged $443 plus an additional $200 under the current law. Am I reading this right?
I believe you are reading that right. The 443, it will include the court costs, it'll include penalty assessment surcharge, it includes the circuit court support fee, and other fees that have been added over the years. And those are all mandatory.
And these go towards court costs, which for the most part are paid for by the state regardless in any case, because they pay for the judge's salary and the court reporter's salary and most of the other salaries except for evidently the administrator or the administrative aide.
Yeah. Some of the money goes to the school fund, some money goes to the general fund, other money is targeted for specific uses like law enforcement training and it's all spoken for one way or another.
Yeah, but,
Not necessarily general fund to pay for.
but my
judges.
guess is that the cost of actually trying someone for a misdemeanor or for a felony is far greater than $600 or $700. If you look at the time spent and the money spent, I don't know if that's an unreasonable fee for a conviction.
Any other discussion on this matter? Supervisor Bates.
Thank you, Mr. Chair. I have a tendency to believe that the individuals who know the most about this are those who have spoken to the issue, including the opinion of our district attorney and our judges. And because they feel that this is not a fee that they can support, I have to feel that I support their opinion.
I see no other requests to speak. One last call, if there's anyone have any comments they'd like to make. Okay, Supervisor Anton.
What is the difference between funding by this means and funding by budget means? It appears that we're putting expenses of the various agencies at risk if we don't have this funding. Isn't this something we should be pursuing as part of a budget rather than adding on somewhere? I know that's not the purpose of this resolution, but underneath this, it seems like we're within the state missing a need to support the various processes more fully with a budget increase somewhere. That's politically not desirable today, but is this not a budget issue? Not for us, but for the state?
Not for us, the state.
We don't have the money to handle these things?
Right, I mean, the Attorney General is going to come in asking for budget, to fund their operations, including the crime lab. And
Why do we have to do it this way is the real question.
I think the question that's before us is a resolution saying, should judges have discretion whether or not to assess the DNA surcharge on every case? Should they have the discretion or not? Current state law says no discretion. The resolution before us is saying we think judges should have discretion. That's really the scope of what's before the body at the moment. Supervisor McKinney.
I would just remind everyone that the request for this originally came from Judge Gabler when he attended a committee meeting. And so the way you just defined it is accurate, that this is a request from the judges that they have the discretionary ability to whether or not to assess this $10 surcharge.
Or not the 10, but the 200 and 250, that surcharge.
Is that?
Yep.
Yeah, thank you.
Anything else before we vote? It appears you're ready to vote, so please do so. Once again, the motion, it's File 51. The motion is concerning File 51, giving judges discretion regarding adding the DNA surcharge to each and every count in criminal judgments of conviction. Supervisor DeLuca, if you'd re-vote there, please. Thank you very much. That motion passes, 21 yes and 5 no. Moving on to File 29.
Ordering attachment to the Lake Altoona District.
I'd look for a motion to remove from the table. A motion by Supervisor Dunning, a second by Supervisor Gatlin, and an explanation by Supervisor Gibson.
Okay, if everybody remembers, this was on the agenda a couple meetings back, I believe, for discussion because we had a timeline to present this, but again, the boundaries that were set by the Altoona Lake District, at one point in time, there were some court hearings to, remove some parcels and stuff from the original district boundaries. And after the boundaries were reduced, there was certain lots were supposed to have been removed, and these two lots, which are in the current Lake District boundaries, somehow was removed from the Lake District, which they are in the boundaries. And So the Lake Altoona District submitted a request to have these brought back in, which needs county board approval. And Planning and Development reviewed this, and I think Corp Council had reviewed everything, and I think those notes are in here. But we recommended approval that those 2 lots be added back into the Lake Altoona District boundaries.
Great. Thank you for the explanation. Questions or discussion on this matter? Questions or discussion at this point this evening? See none? So let me repeat the motion and then we'll vote. So it's file 29, and the motion is ordering attachment to the Lake Altoona District. And if you'd please vote at this time. That motion is, passes unanimously. File 48.
To renumber section 18.76.003, A8 through 30 as 9 through 31 of the code definitions, and to create section 18.76.003, A8 of the code definitions, and to repeal and recreate section 18.77.010 of the code jurisdiction, and to amend section 18.82.060B of the code lot standards.
Thank you. May I have a motion, please? A motion by Supervisor Leary, second by Supervisor Lavelle. An explanation by Supervisor Gibson.
Thank you, Chairman Moore. This is a jurisdiction of subdivision control code, and this ordinance clarifies that a certified survey is required for land divisions that are less than 40 contiguous acres. And this language is clear and simple to understand by both the property owners and the surveyors. And under this current rule, if a land division divided any quarter section, it would require a certified survey, even if the lot was greater than 40 acres. So this pretty much cleans up everything and makes it easier for the surveyors and requirements for certified survey maps. And Planning Development has reviewed this, and we recommend approval.
I heard every word you said. I was just confirming on that last agenda item to be sure that we handled it properly, and Corp Council said we did, in terms of that motion to remove from table and motion to, but it was there from, and earlier it had been moved to adopt, so we're legal on the last legislative matter. Thank you for the explanation concerning file 48. I did hear almost every word you said, but if anybody has any questions, it might help me out. No, I'm only kidding. Discussion or questions on this matter? Any questions or discussion? I see none, so let's vote. The motion is concerning various ordinance changes as explained in file 48. And that's adopted unanimously. Moving on to file 50.
This ordinance changes the county code combining the Exposition Center Advisory Committee with the Parks and Forest Advisory Committee.
May I have a motion, please? Motion by Supervisor Gibson, second by Supervisor Stelgis, and an explanation by Supervisor Lavelle.
Thank you, Chairman Moore. At one time, we used to be able to, didn't have a problem filling these committees. As a matter of fact, we'd go through applications, and I had to turn down people. And if you served 2 terms on the Parks and Forest Committee, you had to get off for a term. But that's all changed. I guess, I don't know if people aren't interested as much in the local government as they used to be. So when the Parks and Forest combined, when we took over the Expo Center, we had 2 different committees. We had the Parks and Forest Advisory plus the Expo Center Advisory Committee. So we decided, the committee decided it would probably be better if we put them together, same amount of people, we'll not add any more people, then we can fill the committee up. And we thought it'd be more interesting for them too. I mean, we got into the Expo Center, we didn't know that much about it. One of the things that we decided is to keep three people, at least three people on that committee would be from, one would be from Corba, the bike people out in Lois Creek. We'd have one person, at least one person from the curling club, and then have one from the 4-H fair, at least. So that would be at least three representatives minimum, and there could be more if there, depends on how they would apply. So we thought it'd be best, we wouldn't have a problem filling up the committees. And the rest of it in this ordinance changes is just housekeeping, where we never did change the Expo Center director to the Parks and Forest director. So, what do you got, any questions?
Thank you for the explanation. Any questions for Supervisor Lavelle or discussion on this matter? Questions or discussion? Appears you're ready to vote. So let's vote. The motion, once again, it's file 50, and the motion is to make amending various sections of the code, but bringing the Expo Center into the Parks and Forest Advisory Committee. And that's adopted unanimously. File 54.
Authorizing payment of vouchers over $10,000 issued during the month of September 2016.
Find that on pages 33 and 34 of the meeting packet. Any questions on this month's vouchers or discussion? Okay, we'll take a motion. What the heck? Motion by Supervisor Bates and a second by Supervisor Willett. Thank you. Sorry about that. Any questions or discussion? I see none, so please vote on the motion to authorize payment of vouchers over $10,000. Supervisor Gibson and Cronig, if you'd re-vote there, please. Didn't quite take there for some reason. Thank you very much, and that's adopted unanimously. And moving on to the addendum, file 56.
Authorizing to convert existing recycling coordinator contract position with Dunn County to a part-time .60 FTE Eau Claire County position.
May I have a motion, please? Motion by Supervisor Clark, second by Supervisor Schroffnagel. An explanation by Supervisor Clark.
Thank you, Mr. Chair. For the last several years, Eau Claire County has been sharing the recycling coordinator position with Dunn County. Dunn County has now offered the recycling coordinator full-time position, and that person has decided to take it. And so we will be left without a recycling coordinator, and it's a pretty important position in the county. So what we are Planning and Development has requested that a new .6 position be created for the county. There's no fiscal impact because the contract position was already budgeted, and any extra would be paid by the grant, the recycling grant funding, which is already in place. And so I would urge you to support this position.
Thank you, Supervisor Clark. Any questions for Supervisor Clark on this matter for discussion? I see none, so please vote. File 56, authorizing to convert an existing recycling coordinator contract position with Dunn County to a part-time .6 FTE Eau Claire County position. That's adopted unanimously. File 57.
Authorizing a title change of 2 crisis response coordinators to crisis response specialist.
May I have a motion, please? A motion by Supervisor Miller with a second by Supervisor Willett. Explanation, once again, Chair of HR Committee, Supervisor Clark.
Our next 2 items come courtesy of the District Attorney's Office. And they have requested to change the title of their 2 crisis response coordinators to crisis response specialists to better reflect the job duties that are assigned and align with the victim witness positions in the DA's office. And our favorite words, there is no fiscal impact. and I urge your support.
Thank you. Any questions on this matter or discussion? I see none. So please vote on the motion authorizing the title change for the crisis response positions in the district attorney's office. That's adopted unanimously. And our last item of business this evening, file 58.
Increase 1.20 FTE victim witness specialist position to .73 FTE and increase 1.625 FTE victim witness specialist position to a .73 FTE.
May I have a motion on this matter? Motion by Supervisor Gatlin with a second by Supervisor Beckfield. And explanation, Supervisor Clark, please.
Thank you, Mr. Chair. Much to the surprise of the District Attorney's Office, the State Department of Justice contacted them and said that they had some money for victim witness people, and would they please apply for a grant, which they did. And the DA's office then received a grant that would allow them to increase the time of the two victim witness specialist positions from 15 hours a week and 25 hours per week, respectively, to both of them working 29 hours a week. And then the DA's office will provide office space which meets the match demand of the grant allocation. There's no fiscal impact. These are the kinds of things that are really fun to have in human resources. You don't have to struggle that much with them. There's no fiscal impact because it's covered by the new money from the new grant.
Thank you. Any questions on this motion or discussion? I see none, so please vote. Once again, it's file 58. The motion is increasing the time for the victim witness specialist positions in the DA's office. And that's adopted unanimously. Thank you, everyone. We're at the end of our agenda. The meeting is adjourned.
This program was recorded and presented by Chippewa Valley Community Television. Chippewa Valley Community Television is made possible by continuing community support. If you would like to volunteer or make a donation, you can contact us by calling 715-839-5067 or on the web at www.cbctv.org.